So before we get into the materials, I sort of want to ask a question to my audience members. How many of you are on social media? You use it personally. Can you raise your hands, please? Pretty much everybody. Almost everybody. How many of you are on TikTok? One. Who's not ashamed to say it. It's a great app, by the way. Okay, Instagram. How many people on Instagram? Okay, just less than half. Facebook? So most of you are on Facebook. How many of you use YouTube every day, whether for educational videos, how to unclog the drains? A little bit higher, YouTube? Okay. And everybody in the room uses Amazon. So we all know how that works. Okay. All right. I think it's highly relevant because I'm going to give you a little fact pattern. It's a fact pattern that I deal with every single day in my practice. And I should tell you a little bit about my practice. I mostly handle plaintiff side defamation litigation or plaintiff side remedies for things that happen online. 90% of my practice touches the internet in some capacity. Either software as a service companies, tech companies, now artificial intelligence, and I understand there was a presentation or there will be one on AI. We can talk about that as well. I deal with salacious text messages going public, salacious DMs going public. My favorite topic, revenge porn. There's just a lot of that happening. You learn a lot about human behavior in what I do, and people like to share more than I thought they would share with other people, and what to do when that goes public or posted online. That's the world that I live in. And so as you can imagine, trying to find a remedy for people who are victims of those issues treads across the First Amendment every day. And maybe in those extreme examples of revenge porn, no one's really arguing that that should be seen by the public. But every single day there are statements made about people where we question, is that worthy of being public information and being displayed? Or should that be something that is deemed damaging? Should we award damages, or should we just have it removed and there's no damages? And these are questions that are asked every single day in my world. So since most of you kind of know how Instagram works, let me put a hypothetical out there for you, or a fact pattern. Imagine yourself, you're sitting here, listening to this presentation, and you get a text message from a very close friend of yours. So you look down at your phone, and there's a link in the text. And your friend doesn't say a word other than, and hopefully you've never had this experience, where you get like 3 or 4 question marks. Maybe your spouse sends that to you when you're supposed to be at the grocery store and you took 30 minutes too long to shop in an aisle you shouldn't be. Question mark, like, where are you? 3 question mark. No one's had that? I guess it's just me. The point is, you get a link and you get a bunch of question marks. So you click on the link. The link populates to Instagram. And you look at the profile and it's your profile picture, but it's not your profile. There's a picture of you. Let's say you're a judge. Judge John Doe Smith. There's a link to your judicial biography from the Court of Appeals or from the Supreme Court. And there's a statement underneath the profile picture that says, "World's biggest pervert." And on the page, there's photos. There's 6 of them. There's a picture of you. There's a picture of your wife. There's a picture of your children, a picture of your home, a picture of your home address, your email and phone number, every way to contact you. And the premise of this page is to say that you engaged in inappropriate contact with a law clerk. Inappropriate contact with a law clerk. Doesn't really say a whole lot. And then there's more pictures that we can construe or imply what that inappropriate contact could be. Memes, if you will, that are salacious in nature, that are sexual in innuendo. You're sitting here, and you get that text message, and you get that link, and you're looking at this thinking, this is a joke, right? But as you scroll, you realize that this page already has 1,000 followers, maybe more than what your real pages have. And for those of you who don't know, Instagram profiles can be verified, right? So you get a blue check mark, which means Instagram takes the position that you've provided the platform with sufficient forms of identity for it to say that that's the person it's purporting to be. And yet, that page, the fake page, is a verified page. So now you're even more troubled. And you keep scrolling and you see comments. And you see comments by other law clerks, current and former. Some of them are saying, yeah, this person was kind of treating me a little weird. Or, yeah, we did kind of brush against each other's shoulders in a way that was awkward, but I still can't believe it. Maybe there's another comment from somebody that says, this is absolutely true. This judge was absolutely a pervert. I felt totally uncomfortable in their courtroom. I felt totally uncomfortable in chambers. Then there's other comments for maybe your kids' teachers, maybe your children. Take this down. This is fake. What's happening is starting to go, as that word that we hear oftentimes, viral, right? There's likes, there's shares. It's been shared 50 times. What do you do? And it doesn't stop there. You're sitting here, that was a scenario. You get this, you leave the room, and you get a call from your son or your daughter. And the call is, Mom and Dad, I just got a text from Joe, my friend Joe. And your 8th grader is telling you that Joe saw your profile. And Joe got a text message which includes a link to that profile. What's going on, Dad or Mom? What's happening? And so we take a few steps back, and you sit and you think, well, I attended Raees' seminar, and he was talking about what the avenues are for recourse. I'm sure there's a way to deal with this. I mean, it's clearly false in your view. But remember these statements, and we'll come back to this later today. The statement made about you was that you're a pervert. And I want you to think about, is that a statement that can be proven true or not true? Or is that an opinion that's not capable of being proven true or false? Because that, as it turns out, tends to be the threshold question when people like you may be looking for recourse to get that taken down. And as you're going to learn, preliminary relief is frequently not allowed. And for good reason, we'll talk about those reasons. But you may have a judge who gets your case. Maybe you call an attorney, maybe you call me, and you say, Raees, I don't care what it takes to get this down. This is false. It's portraying me in a false light. This could cause me to lose my job. I can tell you I'm not a pervert. I didn't say or do these things that are listed in this meme or in these comments. What can we do to take this out of the public universe? And the answer could be you can do absolutely nothing. And that grows in perpetuity to maybe 10,000 followers. And maybe it gets a little bit of media attention. The media loves hype. The media loves controversy. And it would be nothing better than a judge who's on the bench, who's being accused of being a quote-unquote pervert, hitting the media and taking off even more, right? So the question is, what can you do about those things? And what is your source of recourse when that happens? And as it turns out, believe it or not, there is a very clear divide. Plaintiffs, like myself, will argue we can prove it's not capable of, we can prove that it's defamatory. We can prove that this is a statement that is not opinion. Defendants will argue, how are you going to prove that you're not a pervert? Is there an objective criteria for that? Is there an objective criteria? Is it a fact, is my point. And believe it or not, the cases across the country are all over the place. There is no exact, on this fact pattern, there is no, and I chose it for a reason, there is no exact benchmark on what sort of recourse you can get in those circumstances. And these are the things that we deal with. And you can add all kinds of seasoning to this. You can add artificial intelligence on top of this, your face, your image. Maybe there's a text message. It's not hard to duplicate a text message now. Is being portrayed that it's from your phone number to a law clerk saying salacious things that you didn't say, or imagery that you did not send. And yet, when are you going to have your quote-unquote day in court? Because by the time that happens, it's everywhere. It's a scary situation, and that's sort of the playing field that we're dealing with today. And what I'm hoping today to accomplish is not just throwing a bunch of cases at you and a bunch of citations. I think you'll have the opportunity to read that. It's in the materials, by the way, which I'm told is in the app, but I would encourage you to read that on your own time. I don't want to get into some of the nitty-gritty on some of these cases, because I think it's more important that you hear the facts and sort of boots on the ground of what's happening to people and what sort of recourse they're trying to get and what the obstructions are to getting that recourse. And I'll give you the perspectives from plaintiffs like myself. I'll give you the perspectives from the defense like David, and what are the issues that we're dealing with and how we can overcome them. So hopefully when you walk away from today's presentation, you have some more tools in your toolkit, if not a better perspective. So I want to talk about a few different platforms. I didn't ask you about this one, but how many are familiar with Glassdoor? Does everybody know what Glassdoor is? Yeah, Glassdoor is a website where employees can rate their employers. Very simple. As it turns out, this is a $300, $400, $500 million enterprise because you can have paid advertising and you attract a lot of eyeballs. You attract employees who are looking for reviews to see if they want to work at the Court of Appeals or if they want to work at XYZ law firm. And you're going to get employers to see how they are being reviewed. And it's fascinating to me that until 2 months ago, Glassdoor did not verify the authenticity of the reviewers. They did not verify the authenticity of the purported employees. You can imagine the type of problem that creates. The new policy change that I want to tell you about is Glassdoor has officially taken the position that moving forward is sort of our mantra of being authentic, that you can read this review knowing that somebody actually worked at this place. They are now requiring a real name and a real email address to try to verify. And I've never signed up on Glassdoor. I don't know what that verification process is, but it's new, so the data does exist in that server. And we're going to talk about why that's important in a minute. But Glassdoor is an extremely popular place for employees, particularly disgruntled ones, to say whatever they want about their employers, and for the employers to have minimum to no recourse. And there's been plenty of litigation on this. And there's a slide dedicated to motions to compel. If we have time, we'll get into on some of the ancillary litigation that plaintiffs have to go through to just find out who's behind these posts, even when it is blatantly defamatory. So these are three of the trends. And one may ask, why does Glassdoor fight so hard to keep the registered users, the names of those users, out of the public eye? And the answer to that is twofold. Number one, they want to be known as a platform that you as the employee can say whatever you want and we're not giving up your information. And in fact, they have an entire team of lawyers, in-house and outside counsel, dedicated to opposing subpoenas and production requests and making your life miserable if you're a litigator, and filling the courts, particularly district courts in California, with ancillary litigation and making magistrates' lives difficult on the sole issue of do we give up this, who this user is or not. On the flip side, being anonymous online is protected speech. It's protected by the First Amendment. You have a right to remain anonymous and say what you want about whomever you want. And for good reason, because if everybody knew about everything that everyone said, it would have a chilling effect on free speech. So we understand that. But there's certain kinds of speech that doesn't deserve protection, and that's one of the key issues that's still being litigated, and it's never a clear line. TikTok, I saw maybe 3 or 4 people raise their hand on TikTok. I just want you to understand this statistic. TikTok has over 1.5 billion monthly active users. So 1.5 billion people every day go to the application, post, like, view content, engage with people. I have plenty of clients. Many of my clients are content creators. Many of them are lawyers. Many of them make a full-time living creating content on this platform. It is extremely relevant today. And as we've seen and as we've heard now, it can bring to light very, very, very critical things about elections. And of course, we are in an election year, and so social media is on the spotlight. And that's something that every election year, social media gets sort of highlighted in the news. And at least in the last 2 elections, We know for a fact through statistical analysis that Facebook had an impact on an election, on 2 elections. And there's been plenty of data, and that's not a political position that I'm taking. It's just a fact. So we need to understand how that happens. And one of the ways is the virality with which these apps work. A common trend that we're seeing and that's being litigated is trend number 2, disgruntled employees. How do you cross the line? If you are a plaintiff and you are an employer, what can you do to stop an employee that's just spreading lies? And again, it's the same inquiry that we had with the hypothetical or the fact pattern with your fake Instagram profile that somebody created to defame and derail your reputation. And that is this speech that is worthy of being published, or is it tortious and is it defamatory? Defamation has been law in the books for a very long time. I think we all sort of thought we knew what was defamatory, but social media has made that more complex because of issues of public concern. And so this is, a growing trend that we see. Conspiracy theories, right? Frequently, people want to litigate over conspiracy theories. And it's a conspiracy theory to you and me unless we're part of the conspiracy, right? And so this idea of, again, what's fact versus opinion, TikTok makes that extremely blurry. YouTube. We all know what YouTube is. But the first trend is something we really, really need to understand. And practitioners, if you ask any internet lawyer who plays in this sandbox, they're going to tell you the same thing. And they're going to tell you that it is very, very, very difficult to get anything taken down from YouTube, with one exception, maybe 2. Underage content. So if you can prove that somebody in that video was under the age of 13 because of the Children Online Privacy Protection Act, federal statute called COPA, which YouTube purportedly complies with. You need to have verified parental consent. That's one. Copyright issues all day long. So if you can tuck an argument into copyright law and say this is infringing, I'm the author and I can prove it, there's a DMCA process. There's an even quicker, I think now, automated process with AI bots where you click a button, you report it, and YouTube, Google in this case, takes it down. But what if it's none of those things? What if it is, in my fact pattern, the same exact thing with your profile calling you a pervert and that you engaged in misconduct with a law clerk? What if that was a video on YouTube that was going viral and had 10,000 views and likes and shares and a bunch of comments? How are we dealing with that? And the answer is, and I put this in quotes because this is directly from YouTube's terms of service, it's also the #1 objection we get from Google's counsel, which is, we don't adjudicate truthfulness. That's not our job. We're a content platform. And so, is it me or is it really loud in that other room? Hopefully, am I speaking loud enough that you can focus on me? Okay. The question is, we don't adjudicate the truth of this. So what do you want us to do as counsel for these platforms? And by the way, Section 230, and we'll talk about that. We don't have liability for publishing or removing user-generated content. So what do you want us to do? And the answer to that usually is your own terms of service say that harassing content, that fighting words, that speech that incites violence is not protected, that you don't support that on your platform. And I will tell you 9 times out of 10, that's a lie. Because what do these content platforms, what's the product on these platforms? You and the content. So the more content they removed, salacious or not, defamatory or not, the more they want it there. The more controversial, the better. So they don't have an incentive to remove the content. You cannot sue these platforms for defamation, at least for First Amendment issues, because of Section 230. So they don't have an incentive. And this is a problem we're seeing regularly in state and federal courts. We can't compel them to cooperate. Trend number 3 is disturbing. As of 2018, 48% of YouTube users have seen content that seems obviously false or untrue. And the rest of that sentence says, but it's being purported as fact. Right? And we see this a lot. How many people, before you buy a product, like a car or something expensive, you go to YouTube and you type it in to read about it? Do people do that still nowadays? Okay. do some research on a product, even if it's typing it into Google, right? The reality is that competitors and advertisers are paid to derail other competitive products in favor of other products, which speaks to this exact point, which is you don't know the veracity of what you're reading. And it may come from a source that seemingly even looks like it's valid, like Yahoo or Forbes. But it could be an issue, it could be a statement that is 100% fabricated about a product or service. And we litigate these cases. They tend to fall in Lanham Act, unfair competition type of claims in district court, where somebody has hired an influencer to run a defamation campaign on plaintiff's products, making all sorts of claims. People review and read these claims. They make purchasing decisions based on that content, and we can prove some form of harm. But my point is, how are we discerning the quality of information that's on the internet? It's hard. There is no central way to do that. One of the key trends with the First Amendment and defamation litigation in social media is this statute, Section 230 of the Communications Decency Act, which was enacted in 1996. And of course, with like all things internet, the reason this statute was enacted was to protect the Googles, right, and the Yahoos from pornography. So if there was some pornography, some pornographic content that landed on their pages, that landed on their search engine, that somebody found objectionable, for whatever reason, the platforms did not want to have liability because they didn't create it. That's where the origins of this statute came from. In today's context, Section 230 allows platforms like Facebook, like Google, like Instagram, and any other website to essentially gain protection from user-generated content. So if somebody else created it and published it, the platforms use this statute to immunize themselves completely from any liability. And it goes both ways. It's for taking down content, and it's also in the event that they keep the content up. And so Section 230 is frequently argued as, Your Honor, we need you. We need you to give us some recourse as a plaintiff because the platforms won't listen to us. Even if you gave an order that compelled Facebook to take it down, Facebook's not a party to our litigation. Facebook's counsel is going to throw it in the trash. They don't have to follow it. At least that's what they're going to tell you. That's what they tell us. And so Section 230 has become a powerful weapon for these platforms to continue to do whatever they want to do and host whatever content they want to host. Another trend in social media and defamation and First Amendment litigation is the increase in objections that parties get to subpoenas for information in these kinds of cases. Now, this is true in civil cases. It's also true in criminal cases. The leg up in criminal cases is, of course, platforms want to cooperate and they don't want to sort of assist in or hide the fact that a crime may be occurring on its platform. Unless, of course, you've heard of the Craigslist litigation with human trafficking and that whole thing becoming a huge, I don't know how many of you are familiar with this, but it was determined that 90% allegedly of the Craigslist and back page traffic to the web page was being driven by illegal escorting and child pornography. And for that reason, there had to be new laws that were enacted to say, well, we know Section 230 gives immunity, but it doesn't give immunity for child pornography, or it doesn't give immunity for sex trafficking. So if you have that on your sites, you could be criminally prosecuted, and you can read all about this. But moving away from that, and just in the civil context, it is very, 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 very hard to get these platforms to agree and cooperate with a legitimate subpoena. And in the materials, I gave you an example of an objection letter that I received. I think it was from Meta. It could have been Glassdoor. But the objection letter, if you read it, is a alphabet soup of objections. And the challenge with this is if we have litigation in Arizona, we serve a subpoena. The providers are all in California, okay? Most of the content providers. So we domesticate and we serve a subpoena in California. We lay out our arguments. We'll talk about the Moblisa test and what's changed, if anything. But the content platforms automatically object. And they say, we're not giving it for this reason, under California rules, let's meet and confer. So litigants then have to meet and confer in California, or at least according to California protocols. And usually, something comes out of it that's productive to litigants. Sometimes it's not so productive, and you have to move to compel. In the meantime, we have our Arizona litigation. We haven't served anybody. We have to extend our deadlines for service, and hopefully we can make a convincing case of that. But that may happen 2 or 3 times, frustrating plaintiffs and their counsel and Arizona judges who are looking at this saying, your case isn't moving. In the meantime, we're stuck now in a discovery dispute, an ancillary case in another jurisdiction over a motion to compel, because the platforms always rely on the fact they're not liable, and privacy concerns. California, as you know, has the most draconian privacy laws. Sometimes it's helpful if you're a user. It's not helpful if you're a litigant and you're trying to find out who's behind a tortious campaign. So this is a whole layer of litigation that we're now seeing, and it's getting worse. It's getting more complicated. It's getting more costly. Glassdoor actually has an entire body of case law in San Mateo County, in San Francisco County, that specifically lays out, one would argue it's contrary to First Amendment. It's contrary to our case law in Arizona, but essentially gives carte blanche protection to Glassdoor. And if you've never heard this, I would encourage you just to look up Glassdoor's terms of service, where they boast that, we've fought hundreds of cases, we fight thousands of cases, we win all of them, and we really believe in protecting the user. Juxtaposition that with, what is your remedy if you're defamed on social media? And is that worthy of free speech protection? I don't necessarily want to dwell too much into the basics of defamation, the elements of defamation, but I do want to highlight a couple of things that are trending with respect to social media and the difficulties that plaintiffs and defendants on both sides are seeing. And the first, I think I highlighted this in my example, and I chose the word pervert on purpose, but you can substitute any number of statements that are published about people. Racist is another one. If somebody says that you're a racist and puts your face on an article on a blog, is that defamatory? I mean, are you okay with being labeled as a racist? Case law is all over the place on this. How about you're a fraudster? You would think, well, Raees, we know what fraud is. We know the elements of fraud. But what I'll tell you is, what David would tell you if he's sitting here, is that's a legal opinion. If there's disputed facts on whether somebody engaged in the conduct or not, and somebody else calls them a fraudster, there is case law to support the notion that that may not be a statement that's provable or non-provable. It could actually be an opinion based on disclosed facts, right? And some of the cases that we read are sort of these real estate or transaction cases, securities cases, where somebody who may have actually engaged in fraud sues for defamation successfully. And it's troubling. It is extremely troubling. So the standard hasn't changed. Many people don't know this, and litigants get this wrong all the time. It is restatement law that a statement can be true, it can be 100% accurate and truthful, and it can still implicate false light. How is that possible? Because we forget the Hustler magazine case that told us, the feds told us, you have a situation where you, the model who was on the cover of Hustler magazine, was alleged to be a centerfold. And I don't know how this impacted her, was highly offensive to her, because she was a model after all. But she was not actually in the magazine. She was just on the cover of the magazine. And so what ended up coming out of that case was, listen, you falsely portrayed her as being a centerfold. She was not. And that was highly offensive to her. And her, it was very emotional for her. And she has all these damages, right? Because again, the test is not reputational harm like it is in defamation. And so if we apply that, how does that apply today? Well, you can have this Instagram page, and maybe you did say something to a law clerk that maybe was a little edgy. Does that mean you're a pervert? Do you have recourse if you did say something a little bit edgy? I would argue that you still do. Dave would argue that you absolutely don't, and you are just mad that people found out what you said to your law clerk, right? But again, it's the problem that we're seeing today is that more and more cases, and the platforms, frankly, are pushing an agenda that content needs to stay up. And even some of the preeminent cases, and the net choice case, which I want to talk about before we leave here today, there's two cases that come out of, one is out of Florida, one is out of Texas, relating to platforms not having the ability to censor viewpoints. We'll talk about those in a minute. But the point is that platforms are pushing an agenda to keep content up, and they're pushing to make sure that even when there is a clear case of defamation, or what we would think is clear, that it shouldn't actually be allowed to be removed for many, many different reasons. And that's the problem. They're third parties. We can't sue them. So the Desert Palm case, I think we're all familiar with in Arizona. This was a case where a woman who had cosmetic surgery that was botched, or at least she alleges that the surgery was botched, created an elaborate website defaming the surgical group. And the surgical group obviously took issue with that. They lost a tremendous amount of business. And ultimately, at the conclusion of a trial, a jury awarded, I think it was around $12 million in damages to the surgical group. The surgical group went up on appeal, and here's the problem. And this is a tremendous problem for litigants on social media related issues. Plaintiffs assumed, that because it fell into the category of defamation per se, that they did not have to prove damages. Well, it says it right there. You don't have to, damages are not required to be shown. Well, not really. You don't have to prove it as an element of your claim, but if you want the jury to award you money, you have to prove something, right? And unfortunately, they did not have a showing of money damages, and so the entire amount got reversed on appeal. But this suggests to us something very, very important, is how do you show damages on social media defamation? We talked about briefly that these platforms fight data production. If you want to show that so many people clicked on that Instagram profile, that false profile, how do you get that data, right? The person who owns the account has access to that data. There's actually a button if you go on your, even personal accounts, but especially business profiles on Instagram, you can view the data, how many clicks, how many likes, how many shares. But the real back-end data that we want is not available, so we have to issue third-party discovery. And what do we know about third-party discovery in these internet defamation cases? They're long, they're expensive, and the platforms object. So it becomes very, very challenging to get the data that we need to prosecute these cases. I usually recommend clients to hire experts, SEO and forensics experts, who can opine on what it costs to do a social media campaign to rehabilitate your reputation. What's very, very, very popular now is getting the forensics or SEO experts to opine as to how much it costs to do a positive SEO campaign, a search engine optimization campaign, so that when people Google your name, that old Instagram profile or that old blog sort of gets outranked. And there's a cost to do that. It takes time to do that. And some of these experts are able to piece that together. And so that's definitely something we're seeing more of. We talked a little bit about the difficulty with discovery. And Moblisa is every platform's favorite objection. In California, there's a similar test called Krinsky. The idea is that a plaintiff has to meet a pleading standard that is not actually Rule 8. And this one will really throws plaintiff's counsel for a loop. Because Rule 8 is a short and plain statement. But if you want to get third-party discovery, you actually have to meet a standard that is much more difficult than that. And the reason for that is because free speech is supposed to be, you're allowed to be anonymous, right? But you actually have to satisfy a summary judgment standard, which means your pleading has to sufficiently describe in detail with the facts, with affidavits, if needed, to demonstrate that the statements are provably false. This puts a tremendous burden on plaintiffs. And again, this is an issue that when we see litigation relating to Facebook, particularly on the defense side, this is a common defensive motion that we see, is you can't meet the Moblisa standard. But if you make that standard, that MSJ showing, then you are entitled to the discovery. And Under bullet point 2, you'll see there's actually sort of 3 additional requirements. You have to give the anonymous poster notice and an opportunity to respond to the subpoena. The complaint, as we said, has to survive summary judgment other than the identity. And the balance of parties favor disclosure. Usually that's where the First Amendment question comes in. Whether this is speech that is legitimate enough and should be of a matter of public concern that people can see it and view it, or is it something that's clearly defamation, or at least we think it's defamation, and it warrants production of that person's identity, right? You have to satisfy those before these third-party platforms will give up the information on a subpoena. That's burdensome. And so in some of these Doe cases, sometimes we can't find out who's behind it, even when it's clearly defamatory, and that's a challenge. Imagine if it were you again, right? Somebody put that blog up calling you a pervert, saying that they're really a law clerk and that this is anonymous, they're a whistleblower, and this is a Me Too issue, and et cetera, et cetera. And you could never figure out who is behind it. It's pretty frustrating. We talked about this a lot, and we talked about it a little bit, but in the materials I go into this a little bit deeper because I think it's actually interesting and funny, and I took that screenshot from their website where they tout that, we almost always prevail, and it's kind of obnoxious. It's actually highlighted in green on their website. I didn't highlight that, and it's to tell litigants that, listen, when we're forced to go to court, i.e., when you subpoena Glassdoor, they don't produce, and you move to compel, they almost always prevail in protecting a user's anonymity. And they tout on their website they have succeeded in protecting the anonymity of users in over 100 cases. That's probably closer to 1,000 cases. I think they're really minimizing it. But they do dedicate significant amount of effort. And again, with First Amendment litigation and the internet, this is not just Glassdoor. Glassdoor just happens to be a great example. They're probably the most difficult to deal with. But other platforms, we deal with the comparable issue. I want to pause for a second because I feel like this is drinking from a fire hose, and I want to see if there's any questions on anything that I've talked about, if there's something that you want to talk about that I haven't covered, and see if there's any questions so far. No? We're going to jump into Arizona's amended anti-SLAPP statute. This is relatively new. So this arises in the context of a defensive motion that is brought to, at least as defense counsel will allege, that your complaint is based on something that clearly falls into free speech. It's not a prima facie case of defamation. We don't need discovery to show that. This should not wait till summary judgment. In fact, we're going to pause all discovery efforts at the pleading stage. We're not going to allow you to do anything, and we're going to get a ruling that will dismiss your case with prejudice on the merits because it's protected speech. And unlike 12b-6, the statute actually says attorney's fees are granted if we can show that this was a clear free speech issue. So this is new. California and Nevada have had an anti-SLAPP statute on the books for a very long time. Their case law is very well developed. There are probably 38 states that have anti-SLAPP statutes like this. SLAPP is an acronym, as you can imagine. Strategic Lawsuits Against Public Participation. It's just a fancy way of saying that if this is a claim related to free speech, anti-SLAPP statute should slap that lawsuit and potentially grant the defendant attorney's fees because plaintiff shouldn't have sued anyway. Why is is the statute a problem in and of it itself? It is, and I would encourage you to read the statute. There's a citation to it in the materials. It's 12-751, ARS 12-751. The problem is it's not very clear on how this statute works, and we'll talk about the two-pronged test. But in other jurisdictions, it is very clear what the statute is asking litigants to prove and at what stage in the litigation. Is an evidentiary hearing required? Can somebody ask for an evidentiary hearing? Again, the whole point of an anti-SLAPP is if this is clearly something of a matter of public concern, then your case is dismissed. We pause everything. We have motion practice on it. It's fully briefed. and your plaintiff's case can be dismissed. And I have the magical language from the statute here. I just didn't read it to you. It defends, or protects rather, all lawful exercises of First Amendment rights. That includes free speech, freedom of the press, free association, peaceful assembly. And the test is a legal action that involves a person's lawful exercise of the right to petition, the right to speech, of free speech, freedom of the press, and right to freely associate or peacefully assemble. And the statute has two prongs. And this is another aspect of the statute that is not very clear. The first prong is defendant, the moving party, has to show that the issues that are being brought fall into the category of free speech, that it's protected speech. So you brief the court. Here are the statements that are alleged to be defamatory. It's clearly a matter of public concern. It's a political issue. It's an issue relating to perhaps a sex offender, and you're a registered sex offender, and you're just mad that we posted that you're a sex offender. This is clearly a matter of public concern, and or it's true, and you're just doing this to cause me to incur attorney's fees. That's prong one. Now, what's unclear in the statute is the language suggests that the court does not proceed to prong two unless prong one is met. It makes sense. It's supposed to be efficient. So if defense moves and cannot show you're not convinced that this is a matter of public concern, then you should dismiss the motion. That's what the statute suggests. It suggests that you pause and determine whether prong one was met. That's not what we see in practice. Prong two is an opportunity for the plaintiffs to show if prong one is met, and the language in the statute specifically says is if prong one is met, right? If it's shown that this is a matter of free speech and public concern, then prong two, we look to plaintiff side to see if they can demonstrate a prima facie case for defamation, right? Ideally, the way it would work is, again, decide prong one. If there is no reason to move forward, plaintiffs don't need to respond to prong two. From a practical standpoint, that's not what we're seeing. Other states have done it differently as well. So I guess this is an issue that is yet to be determined. We don't have a lot of law on this. And I should say it used to be anti-SLAPP has been on the books in Arizona. The part that's new is this free speech and matter of public concern issue. It used to stop at right to petition the government, which could be a zoning, lawsuit or something. Somebody said something in a zoning hearing. It now is much broader. So as of about a year and a half ago, almost 2 years now, it's much, much broader. The court grants the motion, the anti-SLAPP motion, if it finds that the defendant has shown the case against them was improperly motivated. That's the magical language. Improperly motivated. Unless the plaintiff can show the case is justified by existing law or supported by reasonable argument for extending or modifying existing law. So that, practitioners point out that last leg that plaintiff has to show sounds like a Rule 11 standard. So the argument is, well, don't you already have, a Rule 11 requirement that you have to have a good faith basis? And the argument that's made is it's actually more than that. It's not just a mere Rule 11 standard. You have to actually show these facts by reasonable argument, etc. So some practitioners say it's the exact same language. Some practitioners say, no, it's an additional burden. It's not very clear. But the language reads very, very familiar. So plaintiffs should not bring claims that don't actually have articulable statements that are provably false, or at least arguably not provably false. Here's the two prongs, just juxtapositions next to each other so you can see it. Again, this comes from 12-751. Just want to see what we talk about. Evidentiary considerations. So this is something that it's a trap for the wary, right? Particularly for plaintiffs. So we talked about this idea that you need to have a Rule 56 sort of standard when you're moving to compel third parties in online defamation cases for discovery of who's behind the cloak of an anonymous defamatory page. Well, similarly, the standard in an anti-SLAPP statute, what we learned, and this is echoed in California and in Nevada where we borrowed our statute from, Your evidence needs to reflect the standard of a Rule 56 motion. And so practitioners, and when I've spoken to practitioners, we ask the question, if you take a screenshot and you say, well, this is the statement, can you authenticate it? Or if you're trying to prove harm, reputational harm, can you just send a screenshot of comments that don't belong to any of the parties in the case? Those are not really authenticated. We don't know who those parties are. So you can't really rely on that. So it creates an additional burden. And really the moral of the story for this is plaintiffs have a much more difficult job. If you have a real defamation case, again, going back to our fact pattern of being called a pervert on Instagram, can you survive this scrutiny? I mean, defendants are going to almost always file an anti-SLAPP statute in Arizona now. If the cause of action includes defamation, you can bank on it. And that's going to cause, and I'm not saying this is bad, but this is the push and pull that David Bodney and I talk about, which is now you need to kind of mark off 3 months of motion practice and ancillary proceedings very, very early on. And David would argue, well, Raees, it's for good reason, because if you didn't have a case, you shouldn't have brought it. It should be dismissed, and we should get attorney's fees. Right? And my argument would be, we don't always have the discovery we need to prove our claim, and that's why we have Rule 56 after discovery. It's not at the pleading stage. And this is the push and pull with the new anti-SLAPP statute. California, I would encourage you to read, when you have the opportunity, to look into some of the California anti-SLAPP cases. California is very, very draconian and very, very, very pro-anti-SLAPP. Anti-SLAPP is a ruling on an anti-SLAPP motion is appealable. In California, the attorney's fees are almost always granted if you lose an anti-SLAPP motion. So defendants, there are actually litigators who only do defensive anti-SLAPP practice, free speech and First Amendment cases, and they do them on contingency because they know there's a high likelihood of recovery of attorney's fees. We have yet to see if that's the case in Arizona, but that seems to be the trend around the country. The issue of an evidentiary hearing I should touch upon. Again, Nevada and California both are states that have mature anti-SLAPP statutes. We borrowed from them. There's a question on whether evidence should be required or is it sufficient to move on the papers. In Arizona, it doesn't say that an evidentiary hearing is required. Litigants can ask for it. This is yet to be kind of flushed out. But I think it becomes a question of what facts do you need to meet your prima facie burden before the case could be dismissed. This is another issue that we're seeing, right, from the standpoint of plaintiffs, but also defendants, is preservation. I mean, if that Instagram page goes up and it's about you and it's defamatory, how are we preserving evidence? Well, you can take a screenshot. What if it comes down? What if it's deleted the next day and you don't have it? That requires third-party discovery. And so can you get that third-party discovery before you can file suit and meet the requirements of the anti-SLAPP statute? Maybe you can, maybe you can't. But what's clear, a trend is, particularly for the plaintiffs, is that it's becoming more and more difficult to meet these burdens. And that may not be necessarily a bad thing, because the intention is, if it's free speech, if it's true, it deserves to stay up. But in many cases, it is absolutely false, but plaintiffs can't meet their burden. And so these cases either don't get litigated, the content stays up, or there's an out-of-court settlement where somebody has to pay an absurd amount of money to, unfortunately, really be extorted into paying to get something taken down. So these are just some examples of the types of evidence. And again, every single piece of evidence here would need to be authenticated, right? Every single piece of evidence has to be presented in a competent manner. This is not probably the evidence that we're used to seeing. It's not a contract. Instagram messages, DMs, reels, things that last 10 seconds online, comments, TikTok comments. How are we preserving these things, right? We've even had cases with Tinder, involving Tinder and defamation on Tinder, and how we can, find the discovery and data to prove who was behind these things. It's very, very difficult. I know there's the Arizona rules of civil procedure put emphasis on, ESI and preservation and metadata. And I think the Johnny Depp Amber Heard defamation trial that I know everybody in this room probably paid attention to, it was very interesting for a lot of reasons. But it emphasized this slide, which is that, evidence is your best friend always in all litigation, but electronic discovery is even more important, and metadata is even more important, because metadata doesn't lie, and it comes from a third party. It can't really be manipulated. And there were so many pictures. I always think back to Amber Heard's testimony of, there were objections made about the metadata behind it, and what the jury could hear and couldn't hear. And there were questions about her makeup, and did she sort of fabricate and add more coloring to the images to show that she was assaulted? These are practical issues, right? The problem is the metadata is hard to get in these internet cases. It's very, very costly. It's hard to preserve. And so you have legitimate claims that are never brought, or you have litigants that kind of have to make a 180 or pivot on their strategy because of the inability to prove these things or authenticate them. And it's just made things more costly and created many more ancillary proceedings. I always recommend everyone, and I put a link to an Instagram reel that if you have the materials you can watch on your own time. But the idea is you have to tell the victims early on, when you find something that is about you that you claim is false, you need to do everything you can to preserve that data. You should be talking to those experts early. And most people don't do that, most victims. And it's particularly important in cases relating to sexual misconduct, right? Because there may have not been a criminal trial. It may be an allegation of sex assault, and there's only a civil case about defamation. There's not even a battery case. So we're seeing these cases come up right up at the statute of limitations, close to a year. We don't know if we can get the metadata. We don't know if we can collect it. We don't know. The clients don't oftentimes have these posts, don't have the reels anymore. And so it's becoming more and more burdensome. And I think that's one of the morals of what's new with litigation and defamation in these cases, and it's these sorts of burdens. So this is the section of the anti-lapse statute that specifically relates to awarding attorney's fees. This is in the material. What's interesting is the language here, and I'll try not to read this whole statute as my eyeballs hunt for it, but the idea is, it's right in line 2. If the court grants the motion to dismiss or quash, the court may award the moving party costs and reasonable attorney's fees. Other cases that are trending that are new, and at least the principles of it, a public official's right to ban people from making comments on social media or blocking them on social media. So we've seen this a few times on Twitter/X and Donald Trump, and the ability for official accounts, to ban and block people commenting on that. Is that protected speech? Right? And is that something that, if you're a public official and you have an Instagram or a Twitter account, can you block or delete those comments? And the trend seems to be that you can't. If that's an official page, you can't and you shouldn't, because you're censoring viewpoints. And it's not content neutral. These are two cases that are also very similarly hinge on social media and government officials' ability to, or authority to speak on behalf of the government, and whether it was these were official accounts that these officials could delete comments from. And again, I don't know that there is, that this is going to change. For now, it seems to be these are actually two different tests, believe it or not. Let me say it this way. So there's not unanimity in how we analyze the issue of a government official's Instagram or Twitter account. The Ratcliffe case tells us, these were both decided this year, that the requirement was satisfied because of the close nexus between petitioners' social media pages and their positions as public officials, right? That opinion was vacated. Compare that to Linkey. So the inquiry seems to be that if you use that page for conduct that resembles or reflects your official position, you're not talking about shopping, it's not just dog pics, right? It's official business, then you really can't censor people's content and viewpoints that you don't agree with. That seems to be the trend and the direction that this is going. But it is, quote unquote, a fact-specific undertaking. at least as of these March cases. Any questions so far on anything we've covered? Any of the cases or anything? Okay. I have about 26 minutes left. I have a few slides just on some of the defamation defenses. I think I want to talk about the net choice case. And this is something that David Bodney was going to cover, so I'll do my best just to point these issues out. And they are really important cases on the issue of social media platforms and content censorship. So the net choice case, and I think this may be in David's outline that is available in the link, but net choice v. Moody. So there's two cases involving net choice, and they both are sort of birthed out of the same sorts of issues. One, in Florida, there's one in Florida, one came out of Texas State. Both are very similar. I'll focus on the Florida one. Florida passed a law in 2021 that said that social media platforms cannot censor viewpoints. This was very politicized. It was a GOP-sponsored bill. The politics of it don't really matter from the principles of it, but the history is it was a GOP-backed bill, and their arguments to the Senate were that, look, conservative viewpoints are being censored. And we don't want these platforms dictating what people get to see. Sounds good so far. I think most First Amendment lawyers would agree with that premise. There's one problem. The language of the statute basically says that Facebook and so these platforms can't censor viewpoints, but it doesn't tell us what viewpoints are. And so First Amendment litigators didn't like this and sued and tried to obtain an injunction to preclude the enforcement of the statute. Because remember, the real reason the statute was being enacted was to stop Facebook from removing certain types of political ads and certain types of content that they argued were being censored. Okay? We all know that the government cannot take a viewpoint position on speech. It has to, censorship has to be viewpoint neutral. So this got appealed, and it went before the Supreme Court, and currently, there was oral argument heard in this case in February of this year, and there has not been a ruling. But the central issue in this case is an interesting one. It's whether or not states can tell these platforms that you cannot engage in your editorial decision-making process and decide what people get to see. And David and I have kind of different positions on this. One position is that, look, content platforms are private individuals. They can show you what they want and what they don't want. And there are algorithms designed to show you what they think you want to see. The other argument is, well, there's some motive here behind some of these platforms, and they do censor content. And we can't allow that to happen. And if you censor the content, we can't give users in the state of Florida access to Facebook or Instagram. That's the argument being made on the other side. And I think it creates an interesting dynamic. There obviously is not a ruling yet, but the question is, do content platforms have the right, or are they going to be precluded now, enjoined from controlling what people get to see? And I think it creates a dangerous precedence if those platforms, in fact, are bound by case law that says, no, in fact, you can't control, you can't censor, quote unquote censor. But it's become quite ridiculous, and if you read the briefings on both sides, it's wild, because now the statute's being construed to say, well, does that apply to emails, right? So if it applies to emails, then obviously, is Gmail deleting emails based on viewpoints? Of course they're not. Really what we're talking about is Facebook and Instagram and TikTok and political speech. So we have yet to see an outcome in this case, in any of these cases. The predictions are all over the place. There's probably going to be some sort of reprimand, if you will, to these social media platforms. And again, right now it's free reign. The algorithms show what they think they want to show and what they think you like. And for the most part, I think that's going to continue. We talked a little bit about kind of what's new and ever evolving in with these defenses. But substantial truth I want to talk about, because particularly in the face of artificial intelligence.
There's a question.
Oh, yeah.
Can I ask you a quick question? Just because you're talking about this and you're a practitioner. So can you give us some practical advice when any of us in the room gets the question mark with the link? What steps do you take as somebody that's been defamed from your perspective, and what would you do?
Yes. What do you do when you get the link with the question mark? That's the question? Yeah. I love this question. Well, for one, you have to preserve the link. You have to click on it, and I'm going to tell you exactly how. So the next steps really require timeliness. The second you get a text like that, obviously observe it. Does it have www.instagram.com? Because it could also be, a phishing from somebody purporting to be a friend. And so I'm going to assume that it's not. I'm going to assume it's a text message from somebody you trust with a link to some defamatory content, right? If it's Instagram, your job is a little bit easier. It's a little bit easier in the sense that Instagram, which is owned by Meta, preserves data on their servers, even in the absence of the data from a user standpoint, if it gets deleted. But what you should do is you click it, you get the page, and you take a screenshot and copy and save that URL into, most of your phones, whether you're Android or iPhone, they have like a notepad. Save the URL there. Take a picture of the screenshot and screenshot all of the content. And your job becomes somewhat onerous if there's a lot of content, if there's a lot of images. Save it. The best way to save it, in addition to screenshotting, if there's an individual post, you can click and save, because that will tend to save some of the data behind the image, right? And I'll skip all the ESI and forensics of metadata and whether it's preserved. So now at least you can talk to an attorney with some knowledge about this is what's happened and this is what's going on. You should immediately report it. We didn't talk about this yet, right? But there is a reporting feature on Instagram through the app where you can report it. What would you report it as? Impersonation. This actually happened to me, believe it or not, and I have a pretty decent social media following, where somebody took my picture and it got verified because they used my name and then they added a hyphen and put another name, and they verified the second name, and that's how they spoofed the system. So somebody physically showed an ID that resembled the second name, and Instagram's automated process didn't catch it, and it verified it. Said, "This is Raees, look." And I'm looking at this like, that is not me. That's not my content. And who knows what DMs are going from me to whomever. So you've preserved, you report. And typically you're going to report as imposter. And then you're going to watch the email that you used to create your Instagram account. Because that's the email that's most likely to get a communication from Instagram saying, we're taking it down or we can't do anything. Notice that the content adjudication process is never going to happen. It's either an imposter or it's not. Once they make that determination, you're stuck with the platform's determination. There's sometimes an appeal within Instagram, and I use air quotes because the appeal sucks. It just does. And this is the frustration, right? If you're a victim, you have limited options. You're going to report it. You're going to wait a day or 2 days. Then the appeal is allegedly a human being. It's not an automated AI that scans the image to make a determination if it's you. You've done that. Now, if you're interested in recourse, what's your 1, 2, 3 list, right? You would go to a lawyer who understands that I need to get this discovery and I need to be able to prove that this is defamatory or it's impersonation, whatever your claims are, that you can prove that, because you're not going to even get a subpoena to discover who's behind it without meeting that requirement. So you have to show all the elements, and assuming you can do that, immediately you file a lawsuit. You're not going to get a TRO against Instagram. You're not going to get a preliminary injunction. There's strong case law. It's a prior restraint. It's not going to happen. And Instagram's going to make sure it doesn't happen, and Section 230 will preclude it from happening. So your only other option is you file the suit, you issue a subpoena. A judge in Arizona is going to tell you if they're going to grant your Rule 26 exception to expedited discovery, right? Because there's no disclosure statements, none of that's happened. Assuming you get that, you're going to serve and domesticate a subpoena on Meta. and you're going to ask for, there's a magical language. Magical language is subscriber information. Subscriber information is IP address, it's email address, it could be a cell phone, because we usually require 2FA verification, so you get a text. So you ask Meta for that. You hope they give it to you with no objections. Read my objection letter in the materials if you do. You get the data, and now you look at the data. Is there somebody I can identify from that information that I got? Does it say a real phone number? Can you text it? Can you call it? What about the email? Sophisticated people use Proton Mail. I don't know how many of you have used Proton Mail. It's hard to track who's behind a Proton email address. They're generally immune for subpoena power. So if there's something discernible from that user data, then you've now satisfied at least part of this process. Yeah?
What is Proton email?
Proton Mail, I know, I'm sorry. I say this every day, 3 times a day. Proton Mail is like a Gmail or a Yahoo, but it is hosted on a secure server, and from all of my practice experience, it does not respond, is not subject to US subpoena power. So frequently it's used by people who do these things to people to hide under the mask of anonymity. If you get user data, the subscriber information that shows a Gmail, we know how to subpoena Gmail and say there's malicious conduct going on, tell me who's behind it. But remember, at every step of the way, you're relying on somebody actually using real information, right? Sometimes we get, in this case, and I'll just continue down this path so you know what your options are. Sometimes you get an IP address that is to somebody's home, that Cox Communications issued to a person. And so then your third, sometimes fourth subpoena as a plaintiff is to Cox or CenturyLink, whoever. And they finally will tell you that at this time, on June 17th, this IP address was assigned to Jeff Smith at this address. And that's when we're like, aha, we found it. We found somebody who was involved in this process. Now you can amend your complaint and name them, or you can call them, or you can email them. In the meantime, you should be running a parallel path with the content platform of, you need to take this down. There's an imposter. Who do I call? I've appealed your process. And there's a parallel process of litigation to determine, who's behind it. But that's kind of the 1, 2, 3. It's not a quick, as you hear me talk through it, this has already become a 30 to 60-day process, right? At a minimum, maybe 90-day. And you're assuming that Meta's not going to object, or you're assuming that the data that you receive in response to the subpoena is something you can do something with. So that's your recourse. There's option 3. Okay, so there's reporting to the platform following their appeal. There's a litigation. They're non-exclusive. You can run them in tandem. The third option is your PR strategy. So if you're a person, if you're a public figure, or you're a popular lawyer or a popular judge, you can create a page, or on your existing page, say, this is what's happened to me. This can be a successful strategy because the people that follow you, who are hopefully close to you, can see that that other page is a scam, because you're not going to be able to stay up all night and texting everyone that you know. So you create an image that says, look, this page is not me. Put it in your Instagram story. Put it on your Instagram page. Maybe create a blog that says, this is what's going down, this is a fraud. It will also upset the person who started it, because they're going to realize that they can't hoodwink everyone, right, for so long. But those are your 1, 2, 3s. I know it's not an easy answer, and you can compound the frustration when you start adding salacious allegations that are sexual in nature. And something about the internet and sex, I swear I deal with like 60% of my issues involve sex in some capacity and salacious images. And some of them are manufactured. They're 100% made up lies. And plaintiffs are stuck. They're victims. And we have all these hoops to jump through, and cost and time. And the damage is, it's the true meaning of irreparable harm in those circumstances. So that was a good question. Any other questions on that? I have, I think, about 10 minutes. Am I right? 7 minutes. Okay. Proving damages. This is probably a good segue into proving damages. The issue we're seeing with social media content and proving damages is even if you have a bunch of likes and clicks, and you can prove the forensic side that some people saw this, you still need to prove that there was some quantifiable impact. You're not speculating that I was injured. Who are you going to bring in as a witness? Or what documentary evidence do you have that you can show that I see that a lot of people saw this, but what's the impact of it? You're going to need an expert, probably in these cases. And it's becoming more and more difficult to prove loss of business, even from these viral types of content, because of all the reasons we talked about. The discovery is hard to get, right? So you have to have an expert that can piece together that says, I've looked at the content, I've read it, presuming it's false. It would cost this person $2-3 million in damages, or it cost this person $2-3 million over the course of 5 years to do our PR campaign, to rehabilitate their reputation, and get them back to status quo. It's even more difficult to value, the last bullet point, even more difficult to value reputational harm in social media cases, true and egregious bots. So again, we talked about if people are commenting, there's some indication that people are believing what they read, right? That people believe what is being said is factual, which is something you have to prove in order to prevail in your defamation case. But how do you know these people are not bots? Are you going to call them in as witnesses? You're going to call 2 of them? So the Johnny Depp Amber Heard cases are easy, or easier, in the sense that public figures, and we didn't talk about the standards for public figures versus private. I'm sure you've heard it. We have a different standard because of First Amendment concerns. You're sort of allowed to somewhat engage in defamation. It's not negligent, right? The statements aren't negligent at a negligent standard. If you're a public figure, you have to prove malice or knowledge of falsity, reckless disregard for the truth. So if you're a public figure plaintiff, you have to meet that standard if you're suing. Normally it's a negligent standard. But in non-celebrity cases, the non-Johnny Depp cases, how do you show reputational harm, right? Did you lose a contract if you're a content creator? Did you lose some big deal or endorsement? Sometimes you do. When we have celebrity type of clients who come to us, we can show that they were dropped from the Nikes or from the Adidas of the world because of something somebody said about them and they automatically believed it, or just because people want to tend to distance themselves from allegations, even if they're not true. Are witnesses available? Again, all of this, the damages dichotomy is damages can seem very high, but you still have to prove them if you want a dollar amount. One of my favorite cases of all time, contemporary cases, is the Jean Carroll case and Donald Trump case. And this is from a public figure case. It's a great demonstration of how to prove reputational harm, right? So just a few quick bullet points. Author Jean Carroll, recently had sued Donald Trump for defamation because he accused her of lying in a 2019 memoir that he had sexually assaulted her. Okay? She got $88 million in total from 2 different lawsuits. These were both jury trials and jury awards. And I thought it was just an excellent sort of quote to show you plaintiff's counsel's statement. And here's the quote. When the president speaks, the world listens, especially a president who has access to Twitter. I think it's hilarious, but it's true. And this is coming from Crowley, who is the lead counsel. And he continues, the statement that Carroll was lying to sell books that spread all over the world very, very quickly. She immediately got hate mail, death threats, and horrible messages, which have continued for the last 5 years. So the question is, members of the jury, right? What is it worth to you? If you were sexually assaulted and the President of the United States said, she's a liar, I never did this. There was no underlying criminal prosecution, by the way, in these cases. There was no restitution paid to a victim of assault. And the jury came back very, very hard and said, we would give you a lot of money if it turns out that the president was lying about that. On Twitter, no less. So that's, I skipped some of the materials that David was going to go over, but that's the end of the presentation. You know, it's a complex area of the law. Internet, free speech, defamation, and litigating these cases, it's very complicated. There's a lot of ancillary battles to have, but that gives you a little bit about what it's like to have boots on the ground. I'm happy to answer any questions. If there's any other questions, if this happens to you, what do you do? Preservation, recent cases, if anyone has them.